Thank you, PLEA, for giving me this opportunity. And let me straight away go with the presentation. Now, as far as management of a cooperating society is concerned, it vests with the managing committee. Now, the managing committee is, of course, duly elected by the members of the society. So, in a management of cooperating society, basically that we need to look at it, the general body. When we talk about rights and duties of the managing committee as well as the members, so the word comes management. So the general body becomes the supreme authority. Now the general body, basically we have three types of general body. The first general body, we call it as the first constituted general body meeting, when the society gets registered, and thereafter once in a year, by within 6 months from the close of the financial year, second, that annual general body meeting is held. That means by 30th September of every year, for the accounts which is concluding in the by 31st March of a particular year, within 6 months, that means by 30th September, the general body is held. That is called AGM. And thereafter, of course, by giving 7 days notice, one can also have a special general body meeting to deal with any agenda to deal with that. So, as I was saying, there is a first constituted general body meeting, annual general body meeting, and special general body meeting. Now, these are the meetings which is conducted by the members. Now, the authority of the general body is supreme. So, I'm not going into detail about the sections, but section 72 of the Maharashtra Cooperative Societies Act says any decision taken in the general body meeting becomes the supreme. Of course, it has to be within the four corners of the Act, rules, and bylaws. So, this is how, with the agenda items, a general body can be done. Now, when we talk about management of a housing society, basically the committee has to be elected. In order to get the elections done, managing committee is done. Naturally, there are various types of the members, their voting rights, which we'll discuss. So that is how the rights of the members come in, and they have the rights to elect the managing committee. Now, when we talk about management, again, the financial transaction, at the end of the day, all the transactions are done in terms of money, and therefore managing the bank accounts and keeping the accounts, books of account, and then of course presenting it to the general body is the most important. Now, there is a disqualification and cessation of a committee member. See, it is not that anybody and everybody can become a member of the managing committee. There are certain disqualifications which are being put. Now, one of the major disqualification which is there to become a member of a managing committee, or if you are elected, he ceased to be the member of the managing committee, is regarding defaulter. If a member who has not paid the maintenance for a period of more than 3 months, he is considered or she is considered as the defaulter. In that case, they will be disqualified from contesting the election, as well as if such member is elected and during the process he becomes a defaulter, naturally they will be considered as ceased with a member of the managing committee. Of course, a company can also pass a no confidence amongst the office bearers, but no confidence motion against the committee is not possible. Let us understand, once you elect the managing committee, they will be elected for a term of 5 years. The general body, though it is supreme, they will not be in a position to pass a no confidence against the entire managing committee. However, the managing committee members can always pass a no confidence against the office bearers, that is chairman, secretary, or treasurer. Now, let me just try to explain you in the management, the types of membership, number of shares that they need to hold, who is a nominee, what are their legal heirs, and how the legal heirs can be established, and then subletting of flats. Now, this is, as I was saying, types of membership. Now, when we talk about the types of membership, there are 4 types of members in the cooperative housing society. The first type of member is called member. A member is a person who has joined the society at the time of registration society, or once the society is formed, thereafter you acquire the right title in the building, or you have acquired the right title in the trust, and then you want to apply for the membership, and such member is admitted to the membership of society. So at the time of registration or subsequently after the registration, because you acquired the flat in that particular building or the society, naturally you can become a member. So this is the first member. The second is called the joint member. Now, what is the joint membership? Joint member is a person who has purchased the property jointly and their name is appearing in the share certificate jointly. In the absence of the first member, a joint member has a right to vote. However, such member also need to get an authorization from the first member. That is, member has to authorize. So many people call it as a first member, somebody call it as a original member, somebody call it as a primary member, whatever the name you call, but the Act provides a member. Member, one who is having a joint membership or the joint ownership of the flat is called a joint member. Now, the third type of membership is about associate member. What do you mean by associate member? Associate member is one of the relatives of the member. One of the relatives of the member who is authorized by the member to become an associate member and then, of course, attend the meeting, vote, or participate, all that. So therefore, these types of member, associate member. Now, who are these relatives? The law provides for 12 types of relatives. That is husband, wife, father, mother, brother, sister, son, daughter, son-in-law, daughter-in-law, nephew and niece. These are the only persons who can definitely, become an associate member. How to become an associate member? Yes, make an application to become an associate member by paying 100 rupees. There has to be a recommendation from the primary member, that the first member, that yes, I am recommending this person to become an associate member along with me. And after paying 100 rupees, managing committee passes a resolution, he becomes an associate member. Then the question arises, what is the difference between an associate member and the joint member? The basic difference is, in the case of a joint member, shares and the properties are held jointly. In the case of an associate member, the property rights are not with the associate member, neither the associate member name appears in the share certificate. Number of shares, yes, the new bylaw provides that minimum number of shares required to become a member of the housing society has to be 5 shares of rupees, 10 shares of rupees 50, which means 500 rupees. Yes, the member can sublet the flats. Only thing, they will have to pay the non-occupancy charges, and leave and license agreement has to be registered. A copy of leave and license agreement and the details of the tenant, which is submitted to the police station, need to be submitted to the society, and the society can charge non-occupancy charges to sublet flats at the rate of maximum 10% of the service charges, excluding the property tax. So whatever is the maintenance, let us say 1,000 is the maintenance, out of that 500 is a property tax. You eliminate property tax, whatever remains, that is 500. Of that 10% means 50 rupees you can charge additional sublet charges. It's also called non-occupancy charges. Yes, every member has a right to nominate. On the death of the member, what the member can do, or on the death of the member, whom the shares need to be transferred, who will deal with the society to bring the legal heirs. That is the only limited role a nominee has. Nominee becomes what is known as the trustee, and therefore a person who applies to a membership of a society through a nominee or by a nominee is called the provisional member. So this way we have 4 members. One member, we call it as a primary member, original member, or whatever we call member. Then joint member, who is holding the share jointly. Third is an associate member, who is one of the relatives. And the last is provisional member. A person who is a nominee becomes a member on behalf of his legal heirs, on the death of a member, is called provisional member. Now, as far as the rights of a member is considered, occupy the flat, sublet the flat, hold the shares, contest the election. All the privileges are there with the member. Make the nomination, make the will, all that types, all everything is there with the member. As far as joint member is concerned, yes, all the rights and duties of the member also is with the joint member, except one. In order to contest or get vote, naturally there has to be authority or the transfer of voting right from the member to the joint member. Same thing is associate member. Yes, the associate member also can contest the election. They can vote, attend the meeting, but the limited role is, in order to contest the election, again a NOC from the member is required, and the provisional member gets all the rights of the member. Only thing is, provisional member will not be able to sell the flats and cannot mortgage. However, they can occupy the flat, and then of course if required they may sublet the flats also. But at the end, the duty of the provisional member is to bring the legal heirs on the record. So who is the legal heirs and how can we bring the legal heirs? Because these are all related to the property. Naturally, if there is a nomination, yes, nominee shares will be transferred, but the property will not be transferred. To get a property transfer, the law provides that you should bring some testamentary document. What is this testamentary document all about? Testamentary document means bringing a probate if there is a will. If there is no probate, then bringing the letter of administration or a succession certificate is called testamentary document. As to the beneficiary will make an application to the local district court and get the either probate, will probated, or a letter of administration, and this is under the Indian succession. Of course, the members of the family can come into family arrangement. They can execute certain release deed. They can enter into a family arrangement deed, and they can also get a legal heirship by approaching the competent court, and then apply to the society and get the flat transferred, and from the provisional member get the full-fledged membership. The next question arises as to the management of cooperative society. So in the management of a cooperative society, getting affiliated to the district federation. In every district, there is a district federation. So we have to get affiliated to the district federation, as well as every district there is a central cooperative bank. If it is a Mumbai district central cooperative bank. If it is Thana district central cooperative bank. So one has to get affiliated to district bank. Then types of funds. There are various funds which are given in bylaw number 12 and 30. Sinking fund, reserve fund, repair fund, maintenance fund, major repair fund, education training, and other as may be decided by the general body. Property tax collection. So many funds are there. The major issue is all these funds need to be raised by passing a resolution in the general body. There is a sinking fund, 0.25% of the cost of construction. Repair and maintenance fund, 0.75% of the construction cost per year. And of course, all service charges you can record. But everything has to be recommended by the managing committee and it has to be approved in the general body. Utilization of the funds. Yes, sinking fund can be used by taking the approval from the general body for the major repairs. Reserves and repair fund can be used for the normal repairs of the society. Education and training fund also need to be collected at the rate of 10 rupees per member, which can be used for training the society members as well as the what is known as the employees. Investment, section 70 and the bylaw number 15 provides that the investment has to be done as in a cooperative bank having at least 3 years A grade or in the nationalized bank. Now, levy of charges, section 50, bylaw number 65 to 71 provides for levy of charges. One is raising of fund and the levy of charges. Now, levy of charges is nothing but the managing committee prepares a budget, and then budget is prepared, it is presented with the general body, and then that as per the budget, the contributions are raised. And this contribution, there are two types of contribution. One based on the square foot and the other is based on the number of units. Now, there are service charges like security charges, housekeeping charges, electricity, lift, or these are the charges which are normally recovered equally from the number of flats. Reason being, these charges do not specify or do not give a specific service. For example, a security will be same for whether you are having 3-bedroom flat or 1-bedroom flat. security is given to that particular member and the family. So irrespective of the size of the flat, the service charges, security charges, electric charges, because common area, let us say electricity is there, then this cannot be said that staircase electricity and all. Just because you have more flat, you should contribute more. However, there is sinking fund, repair fund, property taxes, NA taxes, insurance, all these are connected with the land and building. So anything connected to the land and building are recovered as per the square foot. Now, moving forward, yes, limit of cash expense is also given in the bylaw, which ranges from 1,500 to 4,500 per instance. But the income tax also provides that you cannot spend more than 20,000 in cash. So even holding the cash, there is a limit. You cannot hold more than 1,500 or maximum up to 4,500. Cash also cannot be held more than certain limit. Filing annual returns. Bylaw number 146 provides various returns to be filed on annual basis, because ultimately the management of a housing society requires that you are answerable not only to the members of the society, you are also required to comply with certain provisions and required to report to the registrar, who is a regulator. So the bylaw number 46, of course, the section 79(1)(a) and 1B, 79(1)(b) provides that certain types of returns to be filed. For example, there are 6 types of returns which has to be filed on before 30th of September of the every year for the financial year ending of the previous year. So this way you get 6 months time to file those returns. What will be the return? One is the annual activities of the society. Second is the balance sheet, profit and loss account, or audit report, audit rectification report. Then if the elections are due, the number of committee elected. These are the returns that need to be filed. Similarly, when you appoint an auditor, 79(1)(b) provides that you need to inform to the registrar within 1 month from the date of general body meeting, within 30 days of the closure of the general body meeting, regarding the appointment of the auditor, so that the registrar will not appoint the auditor, you can appoint the auditor from the plan. Security for holding cash. Yes, there are so many bonds which you can take, and you can take the insurance also. Appropriation of the profit, 25% of the profit or the surplus, that has to be transferred to the what is known as the reserves. Of course, dues of the society, like delayed interest or any amount which has been charged to the member, that cannot be what is known as, that cannot be, you cannot, and it is not permitted to you to write off unless until that is not recoverable, it is approved by the registrar, and also the auditor gives the certificate. Managing committee meetings, yes, as I said, the compliance. Now let me concentrate on the duties of the managing committee. The managing committee has to meet once in a month. It is a monthly meeting. This is one of the compliance. Every month, whatever expenses are happening, that should be approved. Then approval of the previous managing committee meeting, transfer of flats in the during the period of 1 month. If there is any application for transfer of flat, that will need to be transferred, and also transfer the share certificate. Approval of the membership, like associate member, joint member, provisional member. Nominal member is now not required. Subletting approval, NOCs which have been given for mortgage or anything. Whatever the nominations are issued on monthly basis, any major expenses incurred to be approved, quotation to be approved, any other issue that needs a resolution from the management. Certain activities can be of course delegated to the what is known as committee members, and then what we can do is that this any other issues that requires the resolution, payment to the vendors, statutory payment of taxes applicable, updation of statutory register. There are various registers that need to be updated. That updation of the registers like cash book, ledger, nomination register, share register, and in the compliance, filing of TDS return. Income tax return also need to be filed once in a year. And then there is something called filing of TDS returns and filing of service tax returns. And now instead of service tax, now of course there is a GST. GST return, if at all your compliance is more than 7,500, then you have to file the GST returns. Now, what are the annual compliance? So we have now seen the compliance which need to be done on monthly basis. Then we have seen quarterly basis, that is payment of not only the TDS and also filing quarterly returns. And GST also paying monthly and then filing the quarterly returns. If you are having more than 7,500 rupees contribution per member, if it is less than 7,500 rupees per member per month, then you don't require to collect the GST or pay the GST for those members. Now, annual compliance, yes, you need to do the accounts. That is by 31st of May. You will have to, that is, you will have to complete the accounts. And sorry, that is 15th of May. Within 45 days from the close of the financial year, you have to complete the accounts. Then by 31st of July, you have to complete the audit. And then you have to get the audit report by 31st of August. And then you have to upload the audit report and other things before 31st of August or 15th September. In fact, it should be uploaded before 30th of September. Now, why we are saying do it before 31st of August or 15th September? Because that is the deadline by which we have to issue the notice for the general body meeting. At least 14 days notice has to be given. Before that, the audit has to be completed. Then submission of the audit report to the registrar as well as to the district special auditor. Now, once the audit is completed, naturally you have to get the compliance of rectification. Whatever objection which has been raised in the audit report that need to be complied. The responsibility, of course, lies with the managing committee. Within 3 months from the date of audit report, you have to prepare a rectification report and then upload not only on the website, also submit to the register. So thereafter, we have filing of returns. As I was saying, the managing committee also has to file 6 types of returns on a yearly basis, that is by 30th September. Conduct the AGM before 30th September. And as per section 79B, as I was saying, 1B, you need to again upload the appointment of auditors by taking his consent on the website or at least submit to the register. Now, in the annual compliance, the consent of the auditor need to be uploaded. You have to file the income tax return by 30th September, then letter of appointment to the auditor within, let us say, 7 days of having the general body meeting. Consent of the auditor has to be obtained, if possible, immediately on appointment. Once you give the appointment letter, generation of audit order. Now, this generation of audit order also need to be done by the auditor. You can request him to generate that audit order so that in the government record, the appointment of auditor is finalized. Thereafter, impart training to the members and employees from approved institutions. The managing committee also need to impart minimum 20% of the members training every year, so that once in 5 years, within the term of the managing committee, all the members are getting training. Now, I was just saying that societies have to file mandatory returns. It can be filed online. Now, if the online is not functioning, then you can file offline. Now, where this return has to be filed? Of course, this return has to be filed at Mahasahkar, maharashtra.gov.in, this website, Mahasahkar website. And annual return, section 79(1)(a) says, every society shall file returns within 6 months of the close of every financial year, which such accounts relate to the register or to the person authorized by him. The return shall contain, what are the types of return? One is annual report of its activity, its audited statement of account. And this is how, when you log in, you will get the option. Once you go in the website and you put your society's login and password, you get this option, general option. Whether you want to update the profile, whether you want to update the detail on deemed conveyance, or you want to file the mandate return or auditor selection. So if it is a mandate return, you have to select the mandate return, and then it says what are the 6 types of return that need to be filed. One is the annual report of activity. Once you click annual report of activities, then it will give certain fields. You fill up those fields. What are the fields? How many members are there? When was the last election held? What are the major repairs you have incurred? And how many flats you have transferred? The activity which happened during the year in that housing society is getting captured in a tabular form. Similarly, audit report, balance sheet, and profit and loss account is this return number 2. So average audit report, balance sheet, and profit and loss. Then plan for surplus of distribution, as we discussed. Whatever surplus you get, 25% of that has to be transferred to the reserves. So that distribution, whatever resolution you have passed, if there is any amendment to the bylaws, naturally you will have to update the amendment to the bylaws, and then date of the holding AGM and election. When is the date of AGM and when you are going to have the election, name of the auditor and return of consent. So these are the 6 types of return that need to be filed, and that can be done. Now, annual report of activities. I'm not getting into it. I'm just saying that every year, these are the various activities that we conduct, and this is getting filled. So I'm not here to get more detail on that. If you can just see, it says financial year, name of the society, registration date, number of members, contribution per member per month. These are some of the financial figures. Now, when we talk about management and rights of the member and the duties of the managing committee, rights and duties of the member, rights and duties of the committee member, the most important thing comes. If a member's rights are not honored by the committee, or if the member is not honoring the decisions of the managing committee and the general body, naturally there has to be grievances. Now, redressal of a complaint is also one of the major activities of the management committee, and even the members should be knowing if their rights are violated, then where they can go for their redressal of complaints, where they can complain. So there are basically we have divided the entire redressal mechanism into 7 authorities. You can go to the 7 authorities for redressal of your complaint. What are these 7 authorities? The first is registrar. Now everything cannot be taken to the registrar, so there are certain restrictions. Secondly, some of the complaints you can take to cooperative court. Third is civil court. Fourth is local municipal authorities. Fifth is local authority, local police. Sixth, general body, and seventh is district federation. Now I will give you some of the examples. Anything related to the management of a housing society, or anything to deal with the application made by the member to the managing committee, that will go to the registrar. Now, when I talk about administration, I am talking about conducting the general body meeting, conducting the election, filing an annual return, appointing the auditor, and then issue of share certificate. All this is related to the administration. That will go to the registrar. Now, I said one is administration. The next also will go to the registrar is certain grievances of the member. For example, member has not been admitted as a society member. Suppose a person has purchased the flat and shares are not transferred. Then also we can file an appeal with the registrar. So this way, registrar is judicial and quasi-judicial. Third, a particular member is duty bound to pay the maintenance. And if he does not pay the maintenance under section 154B-29, the society can file a complaint against the member before the registrar and get the amount recovered. So this way, the registrar is available to see that rights of the members are not violated. Now the cooperative code. If there is any dispute regarding the election, dispute relating to the resolution, touching the business of the society, and this dispute is with the member or a previous member, in that case, between the society and the member or the member and the society, somebody is challenging the resolution, validity of the resolution, whether it is proper or illegal, all this will go in the cooperative. Thirdly, civil code. Now, what do you mean by civil? Now, the matter with the civil code is barred if there is a dispute between a member and the society. That will go cooperative code. When we go to civil code, we go to the civil code if there is something called a builder has not given the conveyance, builder has not handed over the accounts, builder has, there is some dispute with the builder and related to the landowner, related to the property, then matter will go to the civil code. Local municipal authority related to water supply, property tax, or civic services will go to the municipal authorities. Local police, if there is something related to Indian Penal Code, like some disputes, manhandling, and theft related to murder, or some dispute which is of a criminal nature, that it will go to the local police, and of course it will go to the magistrate court, session court, high court, and all. Then the general body of the society. See, most of the things which managing committee is not able to resolve in the AGM or in the SGM, that can be taken before the general body. The last is, of course, if the managing committee is not functioning properly, they are not having the elections, meetings, and all. You can also complain to the federation in which your society is, affiliated. Now, conveyance of a land and building is one of the major activities of the society, and the purpose of registration society is to get the conveyance. So, therefore, if the builder does not give the conveyance of land and building in the name of the society, you can go to the district deputy registrar and get the deemed conveyance. So these are the normal documents required for the deemed conveyance: 712 extract, ground number 6, society registration certificate, agreement, copies of all the flat owners with the index 2, notices sent to the builder, list of the members, NA order, building completion certificate. Now, how the conveyance is done by the managing committee? They can definitely approach the builder, get the conveyance deed done, and then finish the job by registering it, by paying appropriate stamp duty, getting the property card in their name. However, if the builder is not doing, then what we need to do is, the society need to apply to the district deputy registrar to obtain the conveyance, and the district deputy registrar will conduct the hearing. And after conducting the hearing, they will give the entitlement certificate, and also they will execute the conveyance. And then you have to adjudicate on the payment of stamp duty. If everybody member has paid the stamp duty, that will be only 100 rupees per member is going to be payable on the conveyance. Then paying 30,000, conveyance deed can be registered. You can get the index 2 and original conveyance deed. And thereafter, naturally, what you can do is, you can apply to the city survey office to get the property changed in your, get the property in your name, that is the society's name, and incorporate the name in the property. Now, Cooperative Housing Society elections, there is a rules of 2014, and in the year 2021, there is another type of society that is called E type of society has been introduced by amending the Cooperative Election Rule 2014. So this way, now we have in the year 2014, election rules were made up to A, B, C, and D type of societies. And now E type of society has been introduced. What is E type of society? E type of society means societies whose number of members are up to 250, 250 or less than 250 in the preceding cooperative year, they are called E type of society. Election of E type of society is done within the society by appointing election officer either within the society member or a person who is in the panel of election officers maintained by the registrar. So you can take either from the panel maintained by the registrar, or any person who is not interested in contesting the election and who is not in the committee can be elected as election officer. That is for the societies having less than 250 members. But more than 250 members, there is a what you call the election to be done by the election authority. Now, earlier definition was like this: housing society having 200 or more, that has now been amended as 250. So I'm not getting into it further, because the today's major thing is to get to know the rights and duties of the member. So I'm not getting deeper into the election rules. If at all you have any questions on the elections and the rights, definitely I will say. Now, election officer, once the election is done, either by the election officer appointed by the society or by the registrar, that person will conduct the managing committee meeting within 15 days, and then he will elect the office bearers also. Office bearer means chairman, secretary, treasurer. So there are various forms which are given in the bylaws. One can go through the various forms, and even the election forms are also given in the election rules. You can follow those election rules and conduct the elections properly. So I'm not getting deeper into that. Now, election charges to be paid for the conducting elections. This is only applicable to C type of societies. But E type of society, the managing committee themselves will, of course, decide with the election officer what will be his fees. So with this, your questions are more important than sharing of my thought process.
So you have mentioned about the members who default in paying the maintenance. Section 154 is invoked under Societies Act. So the one, can you elaborate on that? And the other thing is there is section 101. So if a defaulter member is receiving section 101, the notice under 101, what is the remedy that this defaulter member would have? Plus, there is also an interest charged on the delayed payment. Can still these sections be invoked in such a manner? And is there any provision under which there's a particular amount decided that about this, if there's a default done, the such kind of notice is issued? And uh, first I need to understand this, and I have a little questions related to it.
Yeah, now I may have to, I have not noted down. One, you are talking about defaulter. Who is a defaulter?
Yes.
Okay. And when he will be declared as a defaulter. The
Right.
second is how the recovery will be done. 101, and when that recovery has to be initiated. Correct?
Yes, and any remedy to the member. What kind of reply or remedy the member can?
Remedy to the member, and last is about interest.
Yes, yes, sir.
Okay. So let me start with the one who is a defaulter. As per section 154B1, various definition has been given. In that, one of the definition is a defaulter. So the word defaulter means a person who has not paid the maintenance of the society for a period more than 3 months from the date of issue of either notice or a bill or any one of them. So either issue of notice or even the maintenance bill, if this is not paid within a period of 3 months, he is considered as a defaulter. So I think earlier law was requiring, in order to declare a person as a defaulter, a notice was required to be served, and after an expiry of period of 3 months, he would have been declared as a defaulter. But the new law says even issue of a bill, and thereafter, if this is not paid within 3 months, he is automatically declared as a defaulter. Now the question arises, there is two things. One is due date and the defaulter. Due date is normally mentioned in the bill, and that has to be passed in the general body. It depends on the society to society. Because if society is issuing a monthly bill, they may say 15th of every month, within 15 days of the month, you have to pay the maintenance. Or within 15 days of the issue of bill, you have to pay the maintenance. So the due date is normally said. If it is a quarterly bill, possibly within 1 month from the date of issue of the bill, it has to be paid. So this way, the due date is 1. If a person does not make the payment within the due date, that is bylaw number 71 says, yes, you can charge the interest. Now the interest can be bylaw provides that it can be 21% per annum simple interest or any other rate of interest as may be decided. Maximum rate of interest which can be charged is 21% per annum. Now it requires a resolution. Now that resolution should be very specific, that the interest is payable after the expiry of the grace period. From the expiry of the grace period till the amount is not paid on that principal amount at the rate of 18% or 21%, as it may be decided on a simple rate of interest, the interest will be charged. Now, when you can initiate a process under section 101, now let me tell you, for a housing society, a new chapter has been introduced, chapter number 13B. You may be aware. Now this all starts with section 154B onwards. Now this section 154B onwards, up to, there are 31 sections, 154B, then 154B1 to 154B31. Now all these sections are in chapter 13B, which is a special chapter for the housing society. And in that, the question arises, earlier section 101 was applicable. Now, because it is a housing society, section 154B 29. So What is the difference between 101 and 154B29? There is no difference. The wording, everything is same. If a person defaults the payment and he becomes a defaulter, the defaulter means if he has not paid more than 3 months, then the managing committee will have to issue the notice, at least two notice, first notice and two giving certain period, let us say 15 days or 1 month. And if it is not paying, issue the second notice, that is can be called as a final notice. And thereafter, you go to the registrar, file the complaint, and get the money recovered. Now the question is, what is the remedy available to the member? If the member is aggrieved that certain charges are levied, not as per the bylaws, certain charges are levied which are without resolution, and interest has been charged in spite of making payment. If there is a compound interest, then that particular member need to bring to the knowledge of the registrar when the case is filed as to what he is aggrieved of. The second option to the member is dispute between a member and the society naturally goes in the cooperative court. One can invoke section 91 of the Cooperative Societies Act, and by invoking section 91 of the Cooperative Societies Act, one can recover that money. Or he can also, that particular member also may say that certain charges are levied without passing appropriate resolution, it is against the bylaws, and it is illegally charged. So one member also can file a complaint against the society, either with the registrar or with the cooperative court, and get the necessary verdict. So these are the remedies which are available to the member. I think I have answered all the questions.
I had two questions.
Yeah.
First question is that there is a managing committee member.
Yeah.
I mean, this is an old construction, 3 floors society. A managing committee member who stays on the first floor, and there is a there's only a member, simple member staying on the second floor. There is leakage from his toilet coming directly to his house. If I want to redress, to which forum? Second is that he has changed the location of all the bathrooms and kitchen, all the water supplies, because of which there is continuous leakage in like 3 months, 6 months. So if I want to complain that this was not allowed by BMC, and there has been no resolution or no application made to the society for the change of this location, so if I have to raise this, to which forum should I raise it? And the third question is that there was a garage in the society which was very old from the start, and we are not able to trace the origin of those papers, nor does the member has it that he is actually owner of that garage, nor we have something like that. But in the society bill, he's paying a very nominal rent of 800 rupees. So if I have to get those documentation done correctly, what is the procedure for that?
I think you have three questions. First is, there is a leakage between two flats. Now normally it is the duty of the managing committee to keep the building repaired, updated, so that the structural damage is done very less. So it is a duty of the managing committee. Now the question arises, you have said, yes, even though the leakage is happening, the managing committee is not taking seriously. They may say that it is an internal leakage, you resolve it. Yes, both the members can come together, they can spend upon a common contractor and get it repaired. Now the question arises, if there is no consensus between these two members, then the managing committee has to intervene. And there is a chance that yes, managing committee also may not intervene for whatever the reason, because they think it is an internal matter. But the building status going to get deteriorated. And therefore, who is the authority to safeguard the buildings in a particular locality? That is, let us say in Mumbai. Naturally, building construction, management, maintenance, taking care of the building as a as a regulator is the municipal corporation. Local authority who use the planning approval is the one who has to see that entire building is also kept in a safe way. And if the owner, or there is a managing committee who is not maintaining the property properly, then the municipal corporation will, on the basis of the complaint made by such members, will come, inspect and file a criminal case against the managing committee for not taking required action. So my answer to you is, you said which is the forum where if such leakages are not addressed, where we can go. Similarly, if there is some illegal structure, where we should go. The regulator for the building is municipal corporation. So you will have to go to the municipal corporation, get your grievances addressed. even if internal leakage is not done or even illegal construction is done. Now you may say that municipal corporation also does not take recourse. Naturally, there is a RTI, you can file a RTI, take action taken report, you can file the first appeal, second appeal, or you can also go in the Right to Public Service Act. You can go to Apple Sarkar website, make a complaint, raise your grievances, or if you require, you can also file a writ petition against the authorities who are not taking the required measures. So this is what you need to do. Now you were saying about the garage. Yes, garage. If you have got a garage, you are paying 800 rupees monthly rent, and you do not have the document. Naturally, the documentation, who has given you the garage, that is most important. If it is a closed garage, naturally you must have purchased from the builder. You must have paid certain money. You will have to trace out those documents. Maybe if you don't have the documents, you have to file a police complaint, issue a public notice, and get at least a confirmation from the society that so many years you have been using this garage and you are the member of the society. And naturally, a separate sale certificate to the garage also can be issued. Allotment letter also can be issued to the garage. All this can be done. And secondly, you also can create a certain document like this garage is jointly owned by, let us say, you and your wife. In that case, you can give part of the garage to your wife, create those documentation. You will have to, understand the available documents. Based on that, we will be able to give a very good suggestion to them to make those documents.
My first question is, okay, I have got the answer regarding the delayed payments and also whom to complain, etc. So in that regard, I wanted to ask, like like practically, I wanted to know, like when if the complaint is made to register regarding the defaulters, etc. Like how much time practically it takes for the register to take the action? That is the one question. And the second question is, many times we have seen that societies form rules such as bachelors are not allowed, etc. So, are such rules? Is it legally can they form such rules? And if not, then what is the remedy for that?
First of all, when you file any petition before any authority, whether it is registrar, cooperative court, anywhere, normally law of natural justice demand, and this is the provision of the law itself, that the other side should be given the proper opportunity. When we talk about giving proper opportunity, that means registrar, after receiving the application, he does the scrutiny, finds out if there are any defects in the application, that gets rectified, and then he issues the notice. Normally, once in 15 days, the notices are given. That means the dates are given. So the first date, maybe after the scrutiny is done, the other side will be issued a notice to appear after 15 days. And once that person comes, then actually he will ask for the copy of the petition and other things. Thereafter, of course, he will be asked to give the reply after 15 days. So this way, then that other side, as a right of the allottee or the right of the member, he may ask for the inspection of the document. He may ask for various documents. He may file a reply. Thereafter, he may file a rejoinder. So many things can go on happening. Now, then written argument, all this can happen over a period of 3 to 4 months. So, under section 154B 29, which the registrar we file an application, that takes normally 3 to 4 months. Once the order comes, that order is considered as a certificate of recovery, which is considered to be a civil decree. And thereafter, the special recovery officer who is appointed by the federation will start initiating recovery process. The second you asked me about the bachelor rule. See, not allowing bachelors, spinsters as a tenants in a particular society is absolutely unconstitutional. Everybody has got every right to live, and naturally, the human being, without any caste, creed, religion, or the gender, they can be, or regarding the marital status, you cannot stop. In case such rules are passed by any society, the aggrieved member need to be immediately going to the cooperative court, and the cooperative court will definitely set aside. Because as I was saying, that any rules, any decisions made by a particular society is against the interest of a particular member, then that particular member can challenge that resolution under section 91 of the Cooperative Societies Act before the before the cooperative court. That is also possible, that you need not take because of this illegal activities which are done by few managing committees. The bylaw has been amended, saying that when you are giving the leave-in license, you don't require a permission. What you need to do is you should submit a leave-in license agreement and the tenant's detail. That's all. And the society can charge a non-occupancy charges. So there is no special permission required, which earlier it was there, it has been done away with. Suppose you do these two things with the spinsters or with the bachelor, and the society rule says no, you cannot allow the bachelor. What you need to do is you have to go to immediately to the police station, because barring somebody entering the premises with the valid documents is also you considering as a criminal offense, and the police will definitely summon the chairman secretary, and they will direct that you cannot stop the entry of those people. So this way you have an immediate remedy to go to the police. But I would say that if you are agree with the day the decision is passed, you protest it and then file a petition before the cooperative court and get that resolution set aside.
So there's one more question on the chat box, that funds collected as sinking fund, okay, and they have been deposited in the bank. So can the FD be withdrawn and the funds be reimbursed to the members?
See, this must be regarding redevelopment. At the time of redevelopment, there are old members and there are new members. And old members must have contributed towards the sinking fund and repair fund for the purpose of managing that building. As soon as the redevelopment happens, that building gets demolished. At that time, yes, the general body can pass a resolution that the sinking fund which has been collected for the purpose of a particular purpose, that is already served, and the developer is going to redevelop it. So therefore, that money is not required. You can pass a resolution and distribute to the members in the ratio in proportion in which they have contributed. It is possible. However, if you decide that no, the sinking fund, you are not doing a redevelopment, nothing, but your sinking fund is accumulated, let us say 1 crore, and you all of a sudden you decide that we want to distribute, that will not happen. Third thing, a sinking fund is a long-term investment which is done slowly and by drop, and therefore once it gets accumulated along with the interest and all, it can be used by passing an appropriate resolution in the general body meeting for major repairs. Earlier, registrar permission was required to withdraw the sinking fund. Now that is also not required as per the new model.
Sir, just wanted to ask, are pets allowed in the society? And if yes, and if there is a grievance by any of the member with respect to the safety of children and other people, whom to approach for the same?
See, let me tell you, you must be aware there is a Animal Cruelty Act. Now what happens is, every person has a right to have their pet in their house. And also, even if there are street dogs or street animals, whether it's a cow, or whether it is your dogs, or whatever the animals are there, yes, there are so many animal lovers, they are allowed to do. There's a animal welfare board also, they have come out with a detailed guideline. So if there are some feeders and all, they want to take care, naturally they can do. Now if there are people who want to keep the dog or pet animals in their house, naturally they have to get it registered with the local authority, that is municipal corporation. So unless until the pet is registered with the local municipal corporation, they cannot keep. Third, so many rules and regulations which are already stipulated by the municipal corporation regarding that. And the society also make certain regulation that if at all you are taking it for walking, if you are you cannot say put lot of restrictions, but within the reasonable restriction, the way we put a restriction to the members not to play at certain time or not to undertake certain repairing at a particular time, same way you can do certain rules and regulations which should be enabling the members to have. So now the last very important question you have raised is, in case a particular member is having a grievances about this type of animals, and then what is to be done? Naturally, you will have to report to your municipal this managing committee, and the managing committee can definitely try to address it. And in case the managing committee is not able to address it, for example, in that case you can go to the absolutely go to the registrar, you can go to the municipal corporation, and if required, you can go to the cooperative court. Because at the end of the day, as I said, if there is a dispute between the two members, where you will go? Between two members, dispute will go to the cooperative court. If because of certain animal, because at the end of the day, we are in the civic society where we will not be able to interact and have a direct conflict with the person against whom we are aggrieved. We need to use certain forum, and the best forum is of course managing committee or the general body. Then make certain resolution, otherwise the registrar, or go to the cooperative court, and of course municipal corporation, to verify whether those pets are registered or not. And if there are many street dogs and other things are coming, you can naturally complain to the municipal corporation, who will definitely take care, and it is their duty to take care. Thank you very much. Thank you for giving me this opportunity.